Okay, thank you so much for joining us for today's webinar, Mandatory COVID Vaccinations in Queensland's Community Legal Centres and Not-for-Profit Organisations. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. I'd firstly like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, Antigen, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people throughout Queensland, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a very warm welcome to any First Nations people who are listening to this webinar today. So I'm really pleased to welcome Mackenzie Wakefield, a lawyer in the Employment and Industrial Law section at Maurice Blackburn Lawyers, who'll be presenting today's session. So just as a bit of a background, as we probably are aware, Queensland's recent COVID-19 vaccine plan, as well as an announcement from the Premier today, has implications for CLCs and other non-profit organisations who often deliver legal and social work services in different contexts and settings, such as providing legal advice in prisons, delivering legal education to schools and libraries, and visiting aged care centres. In addition, as employers, CLCs have obligations under work health and safety, human rights, discrimination and industrial relations legislation. So today's webinar will look at an employer's legal obligations arising from COVID public health orders in Queensland, providing directions to staff, including a direction to get vaccinated, employers' consultation obligations and best practice consultation strategies, responding to staff concerns and dealing with staff non-compliance and vaccine hesitancy, privacy considerations, as well as an examination of a number of relevant case studies. So I'll hand over to Mackenzie in just a moment. You can see Mackenzie on the screen there, but I'll let her tell us a bit more about herself when I do hand over. But just before I do that, some quick housekeeping. So today's webinar is being recorded and I'll have the recording available for you to download later this afternoon. The PowerPoints have been emailed out to everyone who registered as of about 10 o'clock this morning, and they're available to download from our website and from the handout section on the GoToWebinar control panel if you missed my email. We, of course, encourage you to ask questions, so simply type your question into the question box on the control panel and I'll read that question out at the end. We will hold those questions to the end of the presentation as there's a fair amount of content to get through. I've also had some questions come in prior to the webinar, so it's a really interesting area and lots of great questions. We will also have a poll to share with you, so please do participate when that comes up and we'll share those responses as well. And I think that's everything from me, so I'll hand over now to Mackenzie to take us away. Thank you, Mackenzie.
Thank you so much, Carly. Thank you all for joining today. It's a pleasure to be speaking to you all on such an important topic. Before I begin, I'd like to acknowledge as well the traditional owners of the land on which I'm on today, which is the Yugambeh people, and pay my respects to their elders past, present and emerging. So in terms of just a brief introduction of myself, my name's Mackenzie Wakefield. I'm a solicitor in our Employment and Industrial Law section here at Maurice Blackburn Lawyers. So I've got experience in pretty much every employment issue that COVID-19 is touching these days, which is just about all of it. So unfair dismissal, discrimination, privacy, bullying, the whole range of it. So we've got a lot to get through today. I understand there are quite a few practitioners joining us today, so this is pitched at quite a sophisticated level, but please, if you have any questions or if I'm going too fast or you don't understand anything, please just pop a comment in the chat box. I'll be watching that as we go along. So I just want to have my camera on to introduce myself to you all, but I'll flick that off now so that no one's internet is affected. So in terms of what we'll be chatting about today, Carly's gone through it, but that's generally the structure that we'll be following. Of course, at the end, if there's anything that we haven't touched on that you think, we'd like to talk about it, that you have particular concerns about, just let me know and we can have a chat about that at the end. Okay, so let's jump into it. So firstly, I just want to touch very, very briefly on the incoming restrictions. I'm sure we're all fairly across it at this point, but that looming date of 17 December 2021 is when restrictions will be imposed, which primarily will affect people who haven't received the COVID-19 vaccination just yet. So this slide was prepared prior to this morning, so there's obviously some additions. So now we're also dealing with correctional facilities, childcare centres, some more of those venues that are potentially more likely to impact your work. It is important to know, though, that at this stage, both vaccinated and unvaccinated people will be able to access essential services and activities. So there will still be quite a broad scope for employers to generally be making their own directions without any sort of government mandates. So we'll jump first into employer directions. So generally speaking, when we're talking about a direction to be vaccinated against COVID-19, there are generally two sources of that direction. So your first is your government mandate, and the second is just a straight up employer direction. So as many of you will be aware, for example, on the 10th of November 2021, the Queensland Minister for Health and Ambulance Services, Yvette Darth, announced the workers in a healthcare setting direction. So under that direction, everybody working in healthcare must be vaccinated by 15 December. Another example is the Queensland government mandate for the vaccine for all truck drivers entering Queensland from another state. They must also be fully vaccinated, and that was by the 15th of November. So what we're really seeing at the moment in Queensland so far, and I should say this is obviously an area that is changing very, very quickly. The announcements just this morning are a pretty clear example of that. But at the moment, Queensland has taken very much an industry targeted approach to mandating the vaccine. And that's quite unlike what we've seen in other states in Australia. So for example, the Northern Territory has recently introduced a mandate that any worker who may, during their work, be exposed to a vulnerable person must be double vaccinated. And that direction is coming directly from the Territory government and is directed to workers generally. And that's perhaps one of the broadest use of a state vaccine mandate in the country, because of the broad definition of a vulnerable person actually, captures an Aboriginal person. So this can be compared to some of the mandates, for example, we saw in Victoria that related to construction workers, which I'm sure some of you will be familiar with. Now, that generally placed obligations on employers, and then it was for employers to direct their employees in a way that would mean they were fulfilling their obligations. But in the absence of any direct government mandate, employers are able to give their employees lawful and reasonable directions. So at present, that discretion has been exercised by employers in a bit of an ad hoc way. So for example, large employers such as Coles have directed their staff in New South Wales to get vaccinated, again in the absence of a state mandate, while Coles workers in Queensland are not required to be vaccinated. So like I said, it's changing very, very quickly, and come 17 December that might change, but at the moment we're seeing quite an ad hoc approach. So today we'll deal with, we'll look at employer directions first, and then we'll explore some of the challenges to the government mandates. In terms of employer directions, an employee has an implied duty to obey lawful and reasonable directions from their employer. Now, if an employee doesn't follow a lawful and reasonable direction, that would generally allow the employer to take disciplinary action against the employee for engaging in that breach or for failing to comply with a lawful and reasonable direction. So there are two requirements within that direction, so lawful and reasonable. They're separate, and lawful is generally the more straightforward of the two, as we'll see. So we'll look at that now. So with respect to whether a direction is lawful, a direction will be lawful if either it is supported by a positive rule of law, or otherwise to the extent that it doesn't involve illegality and it falls within the scope of the employment contract. So there are some things that employers should be looking at, using vaccinations as an example. So the first is, are there any applicable state or territory public health directions mandating the direction? So that's your positive rule of law. So in other words, if there's a public health order that applies, employers and workers will be required to comply with them, and that direction will be lawful. Second, does an employee's enterprise agreement or modern award consider vaccination? So, for example, industries like the aged care sector and the health sector have dealt with vaccinations before, and many employers mandated the flu vaccine. So for those employers, they should be considering whether their enterprise agreement or award is drafted broadly enough to cover the COVID-19 vaccination, or if it only contemplates the flu vaccine. Another source of positive entitlement might be an employee's individual employment contract, whether that considers vaccinations. So there is usually an express term in a contract of employment that has the effect, that the employee will be required to follow lawful and reasonable directions. So that's an express term that will be relevant, but there's also some terms to the effect of making certain vaccinations an inherent requirement or a precondition to fulfilling the role. So certainly the Fair Work Ombudsman has certainly suggested that you can contractually require a person to participate in a vaccination program. Another consideration might be a particular code of conduct, whether that considers vaccinations. So for example, in March of this year, APRA released a position statement stating that they strongly encourage all registered health practitioners and students to have the full COVID-19 vaccination course unless it's medically contraindicated. So that's an example of not a positive legal obligation, but it would certainly be influential when you're looking at whether a direction is lawful. Generally speaking, however, the requirement that a direction be a lawful one doesn't require an express legal entitlement to make that direction. So it's really looking at, firstly, well, is there one? So is there a public health direction, for example? But if there isn't, is there anything else that would mean that that direction is unlawful? So that's lawfulness. Now, when we look at whether a direction is reasonable, it really requires a more discrete approach that allows for consideration of the employee's entire employment and personal circumstances. And that's because whether a direction is reasonable is a question of fact and balance. So what are the factors in deciding whether a direction is reasonable right now? So the answer to this requires the weighing up of factors that support the idea that a direction is reasonable against the factors that support the idea that a direction is unreasonable. So some of the common considerations include so legal obligations. What are an employer's, so obviously employers or persons conducting a business or undertaking in Queensland are required so far as reasonably practicable to ensure the health and safety of their workers while at work, as well as ensuring the health and safety of other persons are not put at risk from the work carried out by the business. So that's certainly one consideration. Another consideration will be the actual inherent requirements of the employee's role. So do the inherent requirements of that role mean the COVID-19 vaccination is necessary to keep them and others safe at work? So for example, does your role require you to work with vulnerable people or high risk people? And that of course is going to vary depending on the precise nature of the role, and it will also vary depending on the nature of the workplace. So for example, an IT consultant who can do her job at home or anywhere with a computer connection, it might not be necessary for her to have the COVID-19 vaccine. If she can perform her duties away from other people and away from the designated workplace, that circumstance, simple social distancing might be considered appropriate in the circumstances. Now, that's not likely to be the case for the majority of workers because most jobs, on a practical level require some physical interaction, whether that be with clients or patients or customers or even colleagues at some point, even if that physical interaction isn't regular. Another consideration, sort of coming off the back of inherent requirements, is who is the employee working with? Are they working, in a care facility or, near or in international travel ports of entry or hotel quarantine hospitals? Those sort of obvious ones. Perhaps for lawyers, a relevant consideration might be, what sort of access does the people that we're working with have to health support? Do they have existing health issues? What is their access like to health services and support should they become sick? Another factor will be the actual efficacy of the direction. So I'm not a doctor, but it's certainly generally accepted that all of the current available vaccines are effective at both reducing transmission and reducing the severity of symptoms of the virus. However, if a person can't get the vaccine because of a genuine medical contraindication, for example, it might be worth considering how much more effective is the vaccine compared to other precautions such as mask wearing or social distancing or working from home. So you've got to actually really consider what is the efficacy of the direction as well. Another consideration for reasonableness might be the accommodation for exemption. So it will always be the case that some people genuinely cannot be vaccinated for medical reasons, whether that is because of allergies or other health problems. And in those circumstances, employers should consider whether to grant medical exemptions and offer reasonable accommodations. Now, as we'll see from a few of the unfair dismissal decisions, the provision of exemptions is not always necessary and it's not always reasonable. It's simply not practicable for all employers to provide exemptions to the COVID-19 vaccination. But most employers should be at least considering whether that is something that they can accommodate. Then you've got your other sort of more practical issues. So, you know, is the employer going to provide time off work for the person to go and get the vaccine? Or if they have side effects, that might also be relevant. Also, the access of the vaccine. You know, in the early stages, obviously, with the Australia's vaccine rollout, there was limited access to vaccines. That's changed now, so there's ample availability. Perhaps though, you know, if you're in a regional or rural community where the access to some vaccines is more restricted, it might be more unreasonable to be required to go and get that vaccine in a really short amount of time. Another factor might be just general, you know, community rates of vaccination. So is there much COVID-19 in the community at the moment? What are the general vaccination rates everywhere? Is it the case that the workforce, this particular workforce, is based in a city or an area with very high vaccination rates? Or are they regional with lower vaccination rates? And finally, just sort of other control measures. So looking at whether there are other measures that can be implemented to mitigate risks. So hand washing, social distancing, mask wearing, all of that stuff that we're really good at by now. It's important to remember though that directions are likely to be lawful and reasonable if the direction goes only so far as reasonably practicable. But as we'll see, industrial tribunals have been quite hesitant to direct employers on how to run their businesses and are generally upholding the employer's right to make decisions about how to best manage their workforce and the risk to their operations. And so then finally, you know, another consideration will be consultation. So it's really important that if required, employers are consulting with their workforce about the new mandate, about its impact on them and any potential timeframes. So if they fail to do that, it might go to the direction being unreasonable in the circumstances. So as you can see, the reasonableness of a particular direction really requires a balancing of all of the relevant circumstances, and it will be very fact and situation specific. Now, having said that, the nature of this particular risk, so that is the risk of COVID-19, does mean that some factors are going to hold more weight than others. So if I could put that to you just by way of a poll, and of all the factors that we just went through, which do you think is going to hold the most weight when we're looking at whether an employer direction to be vaccinated is reasonable? So I'll give you three options. So the first is work health and safety obligations. Second is accommodation for exemptions, so making sure that people who can't get the vaccine are catered to. Or thirdly, the inherent requirements of the role. So what is the actual work that the employee is doing? So I'll give you a bit of time to consider those. That's very interesting, very evenly split there. So about half of you say work health and safety obligations, and the other half say the nature of the work the employee is actually performing. What we're seeing out of both the QIRC and the Fair Work Commission is that work health and safety obligations are priority number one. So at its heart, COVID-19 is inherently a health and safety issue. The inherent requirements of the role are absolutely crucial to any consideration of reasonableness, but only to the extent that they impact the health and safety of both that person, but also the colleagues and the clients that they're interacting with. So that's reasonableness. We'll move on now if my presentation wants to. So this is sort of your ideal vaccination direction. So these are sort of things you want to be looking for to make sure that this direction is going to be lawful and reasonable. So you want to make sure that it's identifying and expressly stating the risk to be mitigated within the specific workplace. So not just, oh, COVID is dangerous. You're going to be saying, if you're if you're working out of an office, we interact with these sort of people, the vaccination rates are low in this area, we get walk-ins, we can't deal with all of our staff, online or whatever it is. So being really specific to the workplace. The second is, what is the source or right of entitlement to issue the direction? So if there is a government mandate, citing that government mandate, or otherwise it might just be the general entitlement of an employer to issue lawful and reasonable directions. Thirdly, making sure that the employee will be provided with an opportunity to respond to the changes, and if there are exemptions, also making sure that they have an opportunity to apply for those exemptions. If they're providing responses for consideration, making sure that they actually will be considered or taken into account by the employer. And then you also might see these other sort of added bonuses. So, if they're getting paid time off work to get the vaccine, and if necessary to recover from it, perhaps over and above your standard personal leave entitlements. And then also covering any costs associated with receiving the vaccine, whether that's travel costs or anything like that. So that's sort of what your ideal vaccination direction might look like.
Mackenzie, I'm just going to interrupt you for a second. We're just still seeing the poll on the screen, so I'm not sure whether you're able to flick back to your presentation for us.
Interesting.
Yes, it's been a bit weird. It doesn't usually keep it up there. It's not, I'm not sharing it anymore, but the software's decided that it wants to keep sharing.
Sure. Okay, I'll just reshare my screen.
Perfect. That's working. Thank you.
Is that better? Okay, great. No worries. So just wanted to zero in on the need for consultation a little bit, because it is really, really important, especially when we're seeing these broad-reaching directions to an entire workforce. For private sector workers, every enterprise agreement made under the Fair Work Act must have a consultation term, and that's found in Section 205 of the Fair Work Act. And that's in fairly similar terms to how it appears in the obligations under the Work Health and Safety Act 2011 as well. So there are quite strict obligations on consultation. So Section 47, specifically provides that, when a person is conducting a business or an undertaking, they must, so far as is reasonably practicable, consult with workers who carry out work for the business or undertaking, or who are or are likely to be directly affected by a matter relating to work health and safety. So COVID-19 vaccinations, as we said, it's inherently a health issue. So it will always be a matter that's relating to work health and safety. In terms of what the nature of the consultation needs to be, sort of everything that you would expect. So it really requires relevant information being provided to the workers, workers being given a reasonable opportunity to express their views or to raise other work health and safety issues, and also to contribute to the decision-making process. Also that the views of the workers are actually taken into account by the person conducting the business. And then finally, that workers are consulted. The consulted workers are advised of the outcome of the consultation in a timely way. And so Section 49 really deals with when consultation is required, and it's fairly broad reaching, and it's safe to say that any imposition of a COVID-19 vaccination direction will meet the requirements of Section 49, will fall into one of those heads. A case that dealt with this fairly recently is the Brussel Delo case. So this was an appeal against the Commissioner of Police's direction that mandated certain police staff to receive their first dose of a COVID-19 vaccine. And the applicant sought to overturn that direction on a few grounds, but most notably because the Commissioner had failed to consult with employees before making the direction, which they say constituted a breach of that Work Health and Safety Act. Ultimately, the Commission accepted that there was, of course, that obligation to consult, but that the obligation had been met. So of note, the Commissioner of Police was able to adduce evidence that the employees had received various documents by email over an extended period of time, which explained the Commissioner's direction, which provided, a list of exemptions, and also provided them, with an obligation to comply with the direction, but also the power to apply for those exemptions. So that was sort of found to be the consultation that was reasonably practicable for the Commissioner of Police to undertake. So that's sort of the theory of lawful and reasonable directions. I think what's most helpful is to see the theory put into action. So the best way of doing that is through some unfair dismissal decisions. Now, it should be noted that because obviously the COVID-19 vaccine directions in workplaces are still fairly new, we don't have any unfair dismissal decisions about those specifically just yet. We do have some other sort of industrial dispute decisions, which I'll cover in a moment, but what we do have is a fair few unfair dismissal decisions for employees who are dismissed because they refused to get the flu vaccination, which many workplaces introduced sort of mid-2020 in response to the COVID-19 pandemic. So this is just how your unfair dismissal cause of action appears in the Fair Work Act. So it's obviously a federal piece of legislation. The first consideration that the Fair Work Commission has is whether there was a valid reason for the dismissal. Now, a valid reason explicitly provides for a reason that relates to an employee's capacity or conduct, which is most relevant to this sort of discussion. Once they've dealt with valid reason, they'll then look at sort of these more secondary issues, so issues of procedural fairness throughout the dismissal process, and then other broader harshness considerations. Now, when we are talking about whether there's a valid reason for dismissal, in terms of a COVID-19 vaccine direction, you're inevitably going to be looking at whether that direction was a lawful and reasonable direction. So you're really looking at the weighing of all the factors that we've just spoken about. So the first decision, I'd be surprised if all of you hadn't heard of this one yet. So it's Glover and Ozcare. It was two decisions of the Fair Work Commission. So the applicant in this decision was a community-based care worker whose role required her to visit vulnerable people in their homes. Now, she'd been employed with Ozcare for over 10 years, but in light of the COVID-19 pandemic, her employer introduced a mandate that required all employees to receive the influenza vaccination. Now, this was around the time that the Chief Health Officer had issued directions which prohibited any person from entering a residential aged care facility if they hadn't had the flu shot. However, it's really worth noting here that the employer direction actually went well beyond the Chief Health Officer direction because it didn't contain, first of all, it didn't contain any exemptions. The CHO advice at the time did contain an exemption. And second of all, the CHO direction only applied to those entering residential facilities, whereas Ms. Glover didn't enter any facilities. Her work just required her to go around the community to clients' homes. But still, the employer said that she was required to get the flu shot. So Ms. Glover, who was 64, refused to get the flu shot on the basis that her parents had told her that when she was a child, she'd experienced an anaphylactic reaction to the flu vaccine and had nearly died. Now, she didn't have any contemporaneous evidence of that reaction, but she did provide a medical certificate to her employer which stated she'd experienced an adverse reaction. Now, at the jurisdictional hearing, Ms. Glover was asked whether she would be agreeable to seeing a medical specialist about her reaction. But she told the Commission that she will never have a vaccination as she believes it would be a risk to her life and that she's not agreeable to meeting with a medical specialist to discuss. So predictably, as a result of her refusal, her employer advised they couldn't roster her for any shifts because she would create a significant risk to their clients. And Ms. Glover argued that she had therefore been dismissed. So in the jurisdictional decision, the Commission found that yes, failing to roster her for any more shifts did constitute dismissal. In the jurisdictional decision, the Commission made some comments on the issue generally, sort of to the effect of what we've already covered, which is that it will be necessary to consider the specific circumstances of each person's role and workplace in determining whether the employer's decision to make a vaccination an inherent requirement of the role is a lawful and reasonable direction. So it's really still a question of weighing all the relevant factors. On the substantive decision, it was for the Commission to decide whether Ms. Glover had been unfairly dismissed. Now, the Commission ultimately found that the decision to make the vaccination against the flu a mandatory requirement without any exceptions was lawful and reasonable. So Commissioner Hunt specifically noted that Ms. Glover's role was not that of a widget maker in a widget factory where her status as an unvaccinated employee might not matter. So it posited that in that scenario, mandatory vaccination against the flu may be lawful, but it may not be reasonable. So that dismissal was upheld. Another interesting note about this case was the Commission heard evidence from an occupational physician about the efficacy of the flu vaccination. And it actually accepted evidence that vaccinations against the flu are not 100% effective, and on average are in fact only about 59% effective against preventing a person from contracting the infection. So I think that's a really interesting point to note today when there's so much conjecture about sort of the available vaccines and their efficacy. The Commission said that's still a material reduction in the risk of transmission, and therefore it's a reasonable direction. So that's Glover and Ozcare. The next one is Barbara and Good Start Early Learning. So in this case, the employee was an early childhood educator. In April 2020, her employer introduced a policy which again mandated all employees receive the flu vaccination. Now, she objected to receiving the flu shot because she had a history of immune diseases such as celiac disease. She'd also had an allergic reaction to the flu shot 11 years prior, though that reaction was not anaphylactic. So on that basis, her employer provided her with a statement to have signed by a medical practitioner, which would mean she could avail herself of the medical exemption to the policy. Unfortunately, she went to a few doctors and they all declined to sign it, so she wasn't able to provide that to her employer. But she submitted that in any event, it had taken her years to cultivate her good gut health and that she was not prepared to risk that by getting the flu shot. So in August 2020, after a show cause process, her employment was terminated and she brought an unfair dismissal application. Now, at the hearing, the employee's submissions focused on her capacity to perform her role as an early childhood educator. So she said, I can still do my job even if I don't have the flu vax. Whereas the employer's submissions were primarily concerned with whether their policy was lawful and reasonable. So Deputy President Lake ultimately found that the policy was lawful and reasonable. And that was for a few reasons. The first is sort of how in line it was with the employer's legal obligations regarding safety. It was noted that it's also in line with government recommendations regarding the vaccination. It noted the efficacy of the flu vax, the duty of care that the employer had towards both children in its care and its employees. It noted that the policy was appropriately adapted and that it did have exemptions for staff who had genuine medical grounds for not getting the shot. And then otherwise it was developed in consultation with the unions who had industrial coverage and provided the employees with a chance to reply to its implementation. So all in all, it was lawful and reasonable. However, the Commission was not satisfied that being vaccinated against the flu constituted an inherent requirement of the applicant's employment. So rather, the vaccination was just a way for the applicant to fulfill her statutory obligations to take reasonable care to ensure her acts or omissions do not adversely affect the health and safety of other persons. So that dismissal was upheld. Kimber and Sapphire Coast Community Aged Care, this has been getting a bit of press lately, so I'm sure some of you have heard of it as well. In this case, the worker worked at a high care aged care residential facility doing receptionist and clerical type duties. She developed a skin inflammation, so a rash on her neck when she got the flu shot in 2016. So then in 2017, 2018 and 2019, she declined to get the flu shot. And then from May 2020, obviously no person was permitted to enter a residential aged care facility unless they had an up-to-date flu vax, and she refused to get it. So by way of supporting documentation, she first provided a letter from a Chinese medicine practitioner. And the Commission really said that based on that letter, it wasn't based on medical science, so pretty well rejected it outright. The employee then tried to get a letter from the GP. That letter said that she had a medical contraindication, but the Commission noted that the GP hadn't attended on her at the time of the reaction. And so in fact, that letter was, the entire basis of that letter was just the employee's assertion that she'd sustained that reaction. So he was just going off what she'd told him. Then in June, the New South Wales Minister for Health commenced a new public health order, and that actually provided an approved form for a medical contraindication. So the employee was asked to have a GP fill that out. And there were a few boxes you could tick for a genuine contraindication, and then there was a fifth box which just said, you know, other medical contraindication. Her GP ticked that one, and then her hand wrote next to it, severe facial swelling and rash lasting 10 months from vaccine. And that was not accepted to be a genuine medical contraindication according to the Australian Immunisation Handbook or the advice of the Chief Medical Officer. So in July, she was dismissed due to, firstly, failing to follow a lawful and reasonable direction, and then secondly, being unable to fulfill the inherent requirements of her role. Now, you're probably seeing a theme here, but Commissioner McKenna upheld that dismissal. In doing so, it was noted that the employer, while the employer hadn't actually directed her to get the shot, that direction would have been lawful and reasonable because it reflected the employer doing its best to apply the Chief Medical Officer's advice and to adhere to public health orders at the time. On the matter of the inherent requirements of her role, it was held that yes, the employee was unable to perform the inherent requirements of her role, given she was not properly permitted to enter or remain at a facility without the flu shot. Interestingly, the Commission noted that a direction to the applicant to get the flu shot would not only have been lawful, but would have effectively reflected what was the law at the time. And as an extension of that, the direction would have been reasonable. So Kimber really provides a black and white example of a direction which reflected the law at the time and indicates that where the policy or the direction matches the law like that, it will likely be both lawful and reasonable. Nonetheless, Kimber appealed on a number of grounds. The majority decision was to deny leave to appeal on the basis that the employer's medical practitioner still hadn't identified a medical contraindication to the vaccine, so she couldn't avail herself of the medical exemption. Now, what's been getting a little bit of press is the dissenting decision, the dissenting judgment of Deputy President Dean. So Deputy President Dean generally came to the view that the employee did have a valid medical exemption, and so she could enter a place of work, and there was no valid reason for her dismissal. However, she also made some other comments about mandatory vaccinations generally, to the effect where she likened vaccination mandates to medical apartheid and segregation, clearly sort of venting her thoughts on COVID-19 vaccine mandates. Now, it's important to note that those comments were made in a dissenting judgment, so they bear no weight on what the majority held. But it's also important to note that Deputy President Dean's judgment has been widely criticised, and she's actually been barred from hearing workplace vaccination matters and has been excluded from full bench work decisions until she's completed some training. So just something to note on the Kimber decision. So those are generally our unfair dismissal decisions as we have them so far. You'll note that obviously most of them relate to the flu vaccine. And while there are obviously some difference between the flu and COVID-19, which I probably don't have to traverse here, they do provide some guidance as to how the commissions are likely to deal with a dismissal as a result of refusing to get the COVID-19 vaccine. So other than unfair dismissals, there have been some other challenges to COVID-19 vaccine mandates, so some industrial disputes and then also challenges to government mandates. So the first is the Brussel Delo case. I'll just flick through this because we've sort of already been through it, but it was found that consultation had happened sufficiently. One of the big ones is, of course, Kassam and Hazard. So in this decision, the plaintiffs were sort of quite broad-reaching. They joined a bunch of applications, so it included construction workers, healthcare workers, aged care workers, teacher, quite a few people, and they were generally challenging the New South Wales public health orders that restricted movement of people who hadn't received the COVID-19 vaccine. Now, essentially, the plaintiffs sought to deploy the principle of legality, which is a rule of statutory construction to the effect that in the absence of a clear indication to the contrary, it is presumed that statutes are not intended to modify or abrogate fundamental rights. However, Justice Beach-Jones noted that this country doesn't have a Bill of Rights, but most importantly, this particular legislation was intentionally abrogating rights with a view to achieving public health outcomes. So the principle of legality was of limited use. The plaintiffs sort of brought a number of different challenges to the mandates, including, that it violated a person's right to bodily integrity, discrimination, and some constitutional arguments. And Beach-Jones dealt with all of them quite succinctly. So on the matter of bodily integrity, just to sort of summarise what's on the screen, it was really found that bodily integrity. Well, first of all, it wasn't really concerned with bodily integrity. It was more about freedom of movement. But that secondly, bodily integrity wasn't impugned because the legislation didn't authorize anybody to, involuntarily vaccinate any person. So right to bodily integrity was sort of dealt with in that way. In terms of, there was an argument put forward that it was sort of vitiating a person's consent to a medical procedure. And Beach-Jones noted that, just because it is a hard choice, for example, if the consequence of not getting vaccinated is you lose your job, that is a hard choice, but it is still a choice. And the effect isn't that your consent is vitiated. So consent to vaccination is not vitiated. A person's right to bodily integrity is not violated just because a person agrees to be vaccinated to avoid a general prohibition on movement or to obtain entry onto a construction site. So that was quite succinct. On discrimination, of course, in Queensland and in Australia, discrimination requires that a person was treated less favourably on the basis of an attribute to another person, either a real person or a hypothetical person who doesn't have that attribute, was or would be treated in circumstances that are the same or not materially different. Now, on this, Beach-Jones really actually noted that there is a material difference between a person who is vaccinated and a person who is unvaccinated. So it's not really possible to do a like-for-like comparison. So any discrimination argument is likely to fail there. And then finally, on the Constitution, so you'll probably all be aware of the arguments around sort of medical conscription, and Beach-Jones dealt with this quite succinctly as well. I might just sort of skip over this just because I want to get through all of our content, but there's quite a bit of commentary online if you're sort of interested in the constitutional arguments. There is another decision incoming, so Johnson and Oars, that will be a decision of the Supreme Court. There was a question as to whether, it's a challenge of the police commissioners and the QAS commissioners' mandatory vaccinations. There was a question about whether it ought to be heard in the QIRC, but the Supreme Court just sort of said, there's plenty of interest in this, so it might be helpful to have a Supreme Court decision. So that hearing will be in late December. And then we've got the Cfmeu and Mount Arthur Coalmine case. Now, this is likely to be quite determinative for private sector employees. So essentially, BHP Group has introduced a requirement that their employees at the Mount Arthur Coalmine in New South Wales must have a single dose of a vaccine by 10 November and then be fully vaccinated by 31 January. They've imposed similar requirements on all of their employees, but the New South Wales restrictions are quite expedited. And the issues raised with these requirements is failure to consult as well. There's questions about whether workers were properly consulted, and then whether generally the requirement is a reasonable and lawful direction. So that hearing was last week. I won't sort of take you through all the ins and outs of it. It was something that my team was involved with, which was sort of great to be in the room, and we're expecting to get a decision imminently. Of note, the BHP advocate, Ian Neal, has put forward an argument that any COVID-19 vaccination direction that is lawful will also necessarily be reasonable. So that's been an interesting argument to see fleshed out a little bit. It should be said that there was a hearing on interim orders, and at that hearing, Deputy President Saunders, who will be a member of the full bench, or who was a member of the full bench, appeared to follow the traditional approach and really consider the question of reasonableness separately to the matter of lawfulness. So that traditional approach being the consideration of all of the factors that we've been through sort of earlier in this presentation. So it will be interesting to see which approach is preferred. And either way, it's a good one to keep your eye out for because it will be quite important for private sector employees. So those are all our COVID-19 related decisions. I just wanted to cover off quickly on discrimination and bullying. It's sort of more of a secondary issue, but always something to be aware of. So obviously engaging in disciplinary action against an employee who, for example, can't comply with a direction because of a medical reason may be prohibited by discrimination legislation. So I've got the Commonwealth legislation on the screen there, but the state legislation is effectually in the same terms. Now, an employer who, fires a person because they have a medical condition or religious belief would obviously be engaging in direct discrimination. However, when it comes to COVID-19, what we're more likely to see is indirect discrimination. So that is where an employer imposes a requirement with which a certain employee, because of a protected attribute, cannot comply. So for example, you must be vaccinated and an employee has a genuine medical exemption, which means that they cannot comply. That may be indirect discrimination. Now, probably quite predictably, a claim in disability or even religious discrimination under the federal legislation is likely to have some complexity. So for example, Section 25 of the Anti-Discrimination Act in Queensland states that an employer may impose genuine occupational requirements for a position. So for example, health employers may consider vaccination against COVID-19 to be a genuine occupational requirement. And there's sort of a bit to say that perhaps that won't just be limited to health employers. But also Section 34 states that an employer may fix reasonable terms in relation to an employee if that employee, because of an impairment, has a restricted capacity to do work genuinely and reasonably required of the position. So when you're looking at whether a requirement is indirect discrimination, there are a number of factors that you'll need to consider when you're looking at whether the term or the requirement is reasonable. They include sort of what are the consequences for failing to comply with the requirement, what's the cost to the employer of alternatives, and what are generally the financial circumstances of the employer. So again, it's going to be a matter of deciding whether the requirement is reasonable in its specific circumstances. So the key takeaway from discrimination really is that just because an employee has a health condition, no matter how serious or genuine, or some other religious exemption, for example, their inability to comply with the direction may not necessitate a finding of unlawful discrimination. So again, it's just going to turn on the circumstances. And then another one to just be aware of is bullying. You'll all probably be aware, but the bullying jurisdiction under both the Industrial Relations Act and the Fair Work Act has a carve out for reasonable management action. So behaviour won't be bullying if it's reasonable management action carried out in a reasonable way. So for example, imposing employer directions is likely to be reasonable management action. However, there are things that will always be bullying. So name calling, any sort of derogatory conduct, for example, towards someone who's not vaccinated, that will always be bullying, and the protections are there under the relevant legislation. So definitely something to be aware of. And then finally, just want to have a look at privacy concerns. So a fundamental question for a lot of employees is whether an employer can collect and handle their sensitive health information. So the handling of personal information is governed at the federal level by the Privacy Act, and that governs the way businesses and government agencies handle personal information. And that's done through the 13 Australian privacy principles. Now, Principle 3 essentially prohibits the collection of sensitive information unless those two requirements are met. So the first is that the individual consents to the collection, and the information is reasonably necessary or directly related to one or more of the employer's functions or activities. So for example, preventing COVID-19 in the workplace is likely to be one of those functions or activities. Now, the first exemption to that privacy principle is that consent is not required where the collection is mandated by law. So for example, in the Northern Territory, employers are required to keep a record of which employees are vaccinated and not vaccinated. So that might be an example of where consent is not required because the collection is mandated by law. Generally speaking, as a general rule, employers should all be acting on the premise of them only being entitled to request the minimum amount of personal information necessary. Other than where it's mandated by law, there is potentially another exception. We haven't seen too much of this being used just yet, but it's definitely one to watch, which is a permitted general situation. So the Privacy Act says that the privacy principles don't apply where, for example, the employer reasonably believes that the collection, use or disclosure is necessary to lessen or prevent a serious threat to the life, health or safety of any individual or to public health or safety. So we can all see how that might be used to justify the collection of, for example, an employee's vaccination status. Now, a couple of cases. The first is Lee and Superior Wood. I'll just sort of skim through this so that we have enough time for questions, but this case essentially dealt with an employee who was directed to consent to the collection of his fingerprints, which he aptly identified as biometric and sensitive information. And the finding was that an employee cannot be directed to consent to the collection of that personal information. So any consent that they do provide, for example, under the threat of disciplinary action, is completely vitiated. I should say that was a decision pre-COVID, so it potentially has limited application. We do have a couple of COVID decisions, which are potentially a little more helpful. The first is Night and One Key Resources. This was where an employee was requested to fill out a survey of the various interstate locations that he'd recently visited and also the ones that he was planning to visit. He refused to do so, citing it was his sensitive personal information, and he was terminated, and he filed an unfair dismissal and argued that the direction was not lawful or reasonable because it was in breach of the Australian privacy principles. Now, it was held by the Fair Work Commission that, first of all, it was unlikely that the information was actually sensitive information, but otherwise, if it was, a general permitted situation existed anyway in light of the COVID-19 pandemic. So which meant that the direction was lawful and reasonable and there was a valid reason for dismissal. And then finally, Member and Enterprises was a decision involving a worker who was dismissed after recording a temperature reading of in excess of 38 degrees. And there was sort of a question there as to whether that's personal information, but it was found that the employer's policy to collect that information and then record that information, so keep that information and collect it, was lawful and reasonable. So that's sort of where privacy is. So look, I've blitzed through that a little bit, but I just wanted to make sure we have time for questions. So I'll just have a look in the chat. Carly, have any come through in the chat?
Thanks, Mackenzie. Yes, we've had quite a number of questions. So I guess maybe we'll focus on a few and see if we can get to as many as we can, but we may not be able to get to all of them. So, Mackenzie, would you like me to just read them out? And you can do
that might be helpful.
Great. So Kelly's asked if you do provide an exemption to a staff member and they contract COVID and pass it on to other staff, is there a consequence to the employer for not providing a safe working environment to those non-exempt staff that then may contract COVID?
Yeah, look, it's going to be, and this is an annoying response, but it's going to be dependent on the circumstances. What the Work Health and Safety Act requires is really that you've done everything reasonably practicable to provide a safe workplace. So I think what would be relevant in that situation is, you know, what sort of evidence did you request from the employee before you provided the exemption? What other sort of measures were introduced to make sure that that employee was, you know, posing as minimal risk as possible to other colleagues? But I think the reality of the case is, you know, there are always going to be medical exemptions when you're introducing this sort of broad-reaching blanket policies. It's just a matter of managing them as best you can, and in ways that's, you know, as reasonably practicable as possible. So it's just going to be a value judgment in every decision.
Great, thank you. The next question is around volunteers. So Aaron's noted that their employed staff have opted to be vaccinated without having to introduce a mandate, which is great, but they've got lots of different volunteers across different categories, including law students, evening solicitors, management committee members, etc. So the question is, do they still owe a duty to provide a safe place of work to all the volunteers, and how can they address vaccination issues with volunteers? Is it in the same way as employed workers? And if not, what factors and considerations would or might be different there?
Yeah, sure. So they definitely still owe the same obligation. So it's really anyone that's performing work in the space that is controlled by the employer or the person undertaking the business. So the same obligations to protect or to provide a safe workplace to the volunteers would apply. My understanding is the directions would still apply in the same way as well. The only difference is that oftentimes volunteers don't have the same protections under the Fair Work Act as employees. So there's more limited circumstances that you might be able to apply for, say, an unfair dismissal. So that's probably something more for the volunteer to be cognizant of, but definitely the same obligations would apply, and the same directions would be applicable to any volunteer.
Great. Kristen has asked, so if there is provision of extra leave for employees to get vaccinated, how fair is that, or would it be deemed unfair for those who have already accessed the vaccine and didn't use, that vaccine leave in the workplace?
Yeah, so we're seeing a lot of employers offer additional leave as sort of a bit of a motivator for employees to be vaccinated, but also it goes to the reasonableness of the direction. So like I said, those sort of practical things that the employer can make a bit easier for an employee will go to how reasonable that direction is. I guess it's probably not fair if you didn't get the extra leave. The question then just becomes, from a legal standpoint, sort of what is your loss? It might be something that you just want to sort of raise with the employer directly, as a bit of a negotiation point. But the issue is that you're really not entitled to leave. It's really the employer's discretion as to what additional leave to offer for a COVID-19 vaccination. So, if the person isn't caring for a family member or isn't unwell, or there's pre-approved leave, in normal circumstances, you're not really entitled to any other sort of leave. And I say that without having seen, obviously, the enterprise agreement or the employment contract, but really the employer has a bit of discretion there to be offering additional benefits if they think it's going to motivate people to get vaccinated. So probably is a bit unfair that you've missed out a bit there, but I guess the question is then, what losses come from it?
This is a good question. So from Christina, is there a work health and safety obligation to protect not only staff and volunteers, but also clients? And if so, what is the source of the obligation?
Yeah, it's the same source. So it's in the Work Health and Safety Act. Definitely still that obligation to anybody who's on the premises. But you also have, in terms of visitors to a workplace, generally employers just have, or employers or people with control of a premises just have a general entitlement to set conditions of entry. So it's definitely still obligations owed to visitors, probably not as strict as they are to employees. And you would probably, I think it would be a bold employer to implement a vaccine on the basis of protecting visitors to the workplace rather than employees. I think it's probably just easier and more legislative supported to protect the employees. That makes sense.
Mm-hmm. And a similar question from Kylie. So, what about requiring clients to be vaccinated in order to access the physical workplace? So, obviously, legal services sometimes can be provided by phone, but often clients will come into the office or will need to come into the office if they've got documents, for example, or need an interpreter. So, is there any way that employers, or any suggestion of what they can or should do in that instance?
Yeah, it's really just a decision for the employer. It's a decision about their business operations and what's most appropriate for them, and again, how they can be fulfilling those obligations to their employees. And generally, a person with control of a building has, or a control of a workplace has, an entitlement to set conditions of entry. So it's really just a decision for the employer to make as to, obviously we're lawyers and we want to be, improving access to justice where we can, but an employer does have very strict obligations to be ensuring a safe workplace for their employees. So like I said, so the tribunals are sort of hesitant to tell employers how to run their businesses. So it's not going to be reasonable to say to an employer, well, you can do telephone appointments, so you should do telephone appointments, you should offer them to everyone. It's just not going to be reasonable in all of the circumstances. An employer is entitled to decide how they run their business and their operations. So it's a decision for them at the end of the day.
This one is a bit of a long one from Sibel. So given how we are all wondering how to exercise our discretion around mandating vaccines, do you consider that in terms of work health and safety obligations of an employer, it's sufficient to adopt the position that CLCs only mandate vaccination where health directions require a person to be vaccinated to perform their role? For example, a lawyer visiting a client in aged care. In other words, given the amount of uncertainty around this issue, is it reasonable to rely on government with all its resources about COVID-19 to direct what should be the appropriate risk settings and therefore just go with that as the appropriate balance?
Yeah, look, that would probably be an appropriate balance. It's definitely a pretty safe option. I wouldn't say it's always necessary. You do still have that employer power to make lawful and reasonable directions. If you are relying on the government mandate, I think you'd really want to still go into detail about, justifying that direction. So still all of that information that we said is important, sort of touching on consultation. So making sure that, if you're introducing that vaccination direction off the back of a mandate, a government mandate, citing that government mandate, sort of providing any information about a risk assessment that you've done. So it's really, really clear that you've actually considered the impact on the workers. So certainly relying on a government mandate is probably the safest option. The reality is that a lot of employers won't have that. And might not have that for some time. So in the absence of a government mandate, it is still certainly within an employer's right to issue lawful and reasonable directions. And some of the cases that we've spoken about today show that a government mandate just won't always be necessary.
This is maybe a bit of an interesting one. So Kristen has asked, how do you decide what is inherent for the role or position? Is that defined by their position as described in the position description or contract, or is it based on what they actually do day to day, which may be a little bit different from the role description?
Yeah, position descriptions don't generally hold as much weight as we might like them to. They're really just more for the information of the employee. Generally, it's the employment contract that will be the deciding factor that really sort of, because whether a direction is lawful, it's going to be lawful unless it involves illegality or it falls outside the scope of the employment contract. Now, sometimes that can be quite unhelpful because employment contracts are often drafted quite broadly with various sort of powers for employers to change, duties and locations and that sort of thing. So first port of call should absolutely be the employment contract. And then you're looking at what are they actually doing day to day, because it's not uncommon as well for, scope creep for people's duties to have changed quite a bit since they signed the employment contract. So I'd be looking at both of those. I probably wouldn't pay too much mind to the position description.
Mm-hmm. Thank you. I might just cover a couple more questions, if that's okay, Mackenzie, for you to stick around for another couple of minutes. So if a staff member has an exemption to getting the vaccine, but they don't provide evidence, where to next for the employer in that situation?
Yeah, it's really going to be a judgment call for the employer. You want to be respectful, obviously, of people's medical exemptions, but you also have those really strict obligations to be providing a safe workplace. And I guess the question becomes, are you doing everything reasonably practicable to provide a safe workplace to your other employees if you're not asking for any evidence of someone's medical exemption? And again, that risk will be different depending on the circumstances. So maybe when borders open 17 December and we get more COVID in the community, that risk is going to increase. Like maybe, it's less reasonable to request, a bunch of evidence now, but it might be more reasonable later on. It's a tricky balancing act, but it is just balancing your need to provide accommodations for people where possible, but also to make sure that everyone else is safe.
Great, thank you. Question here, can we ask unvaccinated frontline staff to wear a mask and or use rapid antigen testing to reduce risk to clients and other staff?
Yeah, absolutely. Absolutely. So really that's just another direction. So asking them to wear a mask, that's another direction, and asking them to undergo testing is another direction. So it really needs to go through that same consideration process, so your lawfulness and your reasonableness. But I think that would be eminently sensible to fulfill a person's or to fulfill a business's work health and safety obligations. I think that's going to be an inevitable next step. So looking at what other measures can we implement to, respect this person's exemption, but also make sure we're keeping everyone else safe. So for sure.
Mm-hmm. And this one I thought was a bit interesting, given many of our community legal centres do receive funding from the Queensland government. So is there any requirement that staff must be vaccinated if there is Queensland government funding received by the organisation?
I don't believe so at this point. I might take that one on notice. That's not my understanding at the moment, is the Queensland government directions are very specific in who they apply to. I don't think it has any impact on anyone who's getting particular funding. I'll double check that though, and I might get back to you, Carly, if I find a different answer. But one of the potentially relevant considerations is just sort of the perception of that. So, you know, it's just like public service employees are held to a higher standard of conduct because they are taken to represent the state and the government. Potentially employers who are receiving funds, you know, theoretically taxpayer money, they might also be held to a higher standard of conduct. So a direction that they be vaccinated might be more reasonable just for those sort of perception reasons.
A comment's just come through from one of our members who asked that question of the Department of Communities, and they said no. So that's interesting.
Interesting.
Yeah. So I might just having a look through the other questions that have come through. So maybe this one would be a good one. So if an employer does mandate or provide a direction that an employee needs to be vaccinated and there are damages caused by the vaccine to the employee, so maybe a health issue arises as a result of the vaccination, what legal responsibilities does the employer have there?
Yeah, it would probably depend on what damage we're sort of talking about. If it's more of a health issue, so for example, if an employer directs an employee to get vaccinated, or there's some other sort of substantial link to the employment. So for example, maybe they give them a voucher to get vaccinated at work, or there's some sort of vaccination program. If an employer directs an employee to be vaccinated and then they sustain an injury, generally that will be a compensable injury under workers' compensation legislation. You've really just got to establish that connection to the employment, which, I mean, again, it's going to depend on the circumstances. So that's sort of my first thought in terms of damage. I'm not sure what other sort of damage might be compensable. It's probably more something you want to be considering before the vaccine. So, for example, if it's travel costs, or you know, potentially you've got to hire someone to look after your kids while you go and get it done, it's more something to be negotiating with your employer beforehand. Otherwise, you're probably just subject to the standard entitlements, so your workers' compensation, but also your sick leave, or your carers leave, or your pre-arranged annual leave. But it would depend on what sort of damage is incurred and how responsible the employer is for it.
Yeah. This question from Rod is a good one as well, I think. So is there a work health and safety do work health and safety obligations need to be equitable across an organisation or roles? So for example, if at one site a person has leave or can arrange a rapid antigen testing, but another cannot, or perhaps another way to frame that up would be if there are particular roles that are going into certain settings where they are interacting with vulnerable clients, can you mandate vaccination for those roles and not others?
Yeah, there's a bit of a balance here, because obviously the employer has to conduct a proper risk assessment, and that should be sufficiently individualized for the various different roles. But at the same time, there's also, a recognition that, an employer has the right to manage their workforce how they want to manage their workforce. And so if you had a challenge to that sort of direction, the Commission's going to look at, well, what are the practical implications of an employer having to issue, 500 different directions to one workforce? Is that worth it? Is it reasonably practicable? Again, it's those sort of value judgments. So there's a bit of balancing to be made. I think if you've got, some employees that are very, very different, so you've got some employees who are working completely from home, who never have any interaction with anyone, the risk assessment for them in terms of COVID-19 is probably going to be very different to someone who's out in the community every day. You're going into correctional facilities or healthcare facilities or aged care facilities. You would expect those risk assessments to be very different, and you would expect some flexibility in the directions. But again, you also have to take into account that an employer is entitled to manage their workforce how they see fit. It would just go back to considerations of how reasonable this direction is in the circumstances. I feel I'm sorry if it's frustrating that I keep saying everything depends, but it really is based on the circumstances. It's just a balancing exercise.
No, that's totally fine. I'm sure that our people understand. Being many, having many lawyers among us. So I might take this one as our final question of the day, and apologies for those whose questions I wasn't able to get to, but this one's just a nice quick one. So is there a definition of vulnerable persons, and is it reasonable to require employees dealing with vulnerable persons to be vaccinated?
It would have to depend on the particular direction. So you would want to look at the specific directions of the Queensland government. They usually will provide a definition for vulnerable person. But generally, and again, depending on the circumstances, generally vulnerable people are the #1 justification for a mandatory vaccination. So you've sort of got two groups where it will nearly always be a reasonable direction. You've got your high risk groups, so the people who are at higher risk of contracting COVID, so those working in, for example, airports, quarantine facilities. And then you've got those working with vulnerable people, so people who are at a higher risk of death or serious illness if they do contract COVID-19, so aged care or healthcare. Those are generally the two groups that are pretty clear cut, that a mandatory vaccination direction will be lawful and reasonable. Again, it would depend on the circumstances. Generally, I found the directions to be quite useful in actually providing definitions for vulnerable persons. So if there's a particular government mandate that you're concerned with, I'd check those. Otherwise, if we're talking about an employer direction, it's definitely something that you'd want to see. That just goes part and parcel with the employer providing as much information as they can to the employee. So you'd want to see an explanation of those sort of key terms if it's just coming from the employer.
Great. All right. Well, thank you so much, everyone, for all of your great questions. Obviously, it's an area that will continue to develop and that we'll continue to watch. And for CLC members, we'll certainly share any resources that we come across that might be useful in your workplaces and to support your staff as well. So thank you so much on behalf of everyone joining us today to Mackenzie for sharing her time and expertise with us. It's been extremely helpful and great to go through some of the case law that's relevant in this area. Before I let you go, I'll just remind everyone, if you can, please complete the feedback survey that will pop up on the screen once the webinar is closed down, because that is really helpful to us. And once again, thank you to Mackenzie for joining us today, and to Maurice Blackburn for allowing her to share her expertise and time with us.
Thanks so much, Claire. These questions have been absolutely great. So thank you so much for all engaging and participating so much. I hope this has been helpful, but it's been a pleasure chatting with you all.
Wonderful. Thanks so much, everyone, and have a wonderful day. We'll see you at our final webinar for the year in December. Thank you.